the topics you may be thinking of, maybe not thinking of, and then we'll move forward with the questions. We did get 2 questions by email as part of the registration process, and I will address those as well once I start answering all the questions. So just a very brief marketing. Welby, Brady Greenblatt, we do construction litigation. We're based out of White Plains, but we really practice in the entire tri-state area and really up and down the East Coast. So thank you again. So the construction industry will be one of the many sectors hard hit by the impacts and disruptions of COVID-19. Construction general contractors are faced with unprecedented uncertainty caused by the wide project shutdowns, labor and material shortages, subcontractor performance issues and defaults, and questions about the application of contract provisions and insurance language. So there are several best practices that contractors should consider now to prepare for the recovery that will eventually happen. I would caution you as you start getting calls from your customers, be very, very careful to be mindful of crossing the line into providing legal advice versus insurance advice. I know we all want to be helpful to our clients and customers, but we want to do so in a manner that protects all our licenses and our livelihoods. So what are the goals during and after COVID-19? Number 1, we want to promote the safety of our employees. Number 2, we want to manage losses, and that could be because of reduced customer and user demand, decreased productivity, especially if we're going to be practicing social distancing, facility closures, project delays, and finally exposure to third-party claims for bodily injury and property damage, and other risks associated with that. The insurance coverage question will be a fact-based analysis. The insured should not assume that they lack coverage. You focus on the insured specific facts, the policy terms, and also the policy period, something that may be overlooked. So even in jurisdictions where there's a stay-home order that exempts construction, or as we are coming back online and we have essential construction continuing to work and some more, as of May 15th, we're looking at least in New York, a lot of projects coming back online. We're going to be facing severe schedule impacts to the extent that, for example, a builder's risk coverage is tied to the policy stated scheduled date of completion. That date may no longer be achievable. So we want to make sure that if an extension of that policy is necessary, that it be implemented. Same thing with OSIP and CSIP policies. They require the project be completed as defined by the policy, not necessarily by the participants. So if it's not completed during the policy period, that's another thing that needs to be looked at, and those metrics have to be looked at. So remind your insureds to contact you if an extension is necessary. Finally, keep on top of the scientific community and the information that is being transmitted. This is a mutating virus. So on a daily basis, what we think we know, what are the signs and the symptoms, that may change. So just be aware of that. Don't think you have a policy today and then put it away and then not look at it and update it. A lot of the information, especially early on when this hit, when clients were calling with questions, the call would be prefaced with, realize this information may be stale by the time we get off this call. So that's not necessarily as true it is today, but it certainly does bear some consideration. So some practical advice. In addition to analyzing the policies for potential coverage, make sure notice is provided. If you don't put notice to the carrier, that's a guaranteed way of not having any coverage. So take a look at your insurance and management program. See if there's any opportunities to supplement coverage at this point. Advise your insurers to keep detailed records of information, such as staffing, who is on a project, when do they leave, when do they move from one project to the other. Document, obviously, extra expenses, expediting, procurement of additional PPE, or other loss mitigation types of costs. You want to have the insured be in a position to be able to support their claims with comprehensive reports. That is going to be a lot harder to create after the fact versus if they're doing it along the progress of the job. Especially loss of business income is something that they need to be aware of. Ask your insurance how the virus has impacted their risk profile. Business slowdowns or complete closures of insured properties may reduce certain exposures and introduce others. For example, think about the effect of delayed delivery of building materials and products. That may give rise to an enhanced risk for builder's risk coverage. Where projects or facilities have been closed or are vacant, there's a greater potential for loss or damage for theft or vandalism, or water damage due to delayed discovery. So these are the kind of things that you want to be asking questions about to make sure that your customers have coverage for. Tell your customers to begin an early discussion and plan for renewals. Changes in operations and locations, even number of employees, will be part of that conversation, as well as changes in potential coverages that they may need bolstered. Realize that the carriers will also need additional time in evaluating these enhanced risk profiles and different risk profiles. So the renewal process may end up taking a little bit longer than it usually does. Turning to the job site, if someone has tested positive for COVID-19, one of the questions that we received is would there be coverage for the decontamination of the work? The answer is possibly. Some property and environmental policies may cover decontamination and other similar expenses. These policies can include additional coverages that may apply for communicable disease cleanup, crisis management, and emergency vacating expenses. Does the insured have an obligation to minimize loss? Absolutely. Whether it's an insurance issue or not, mitigation of damages is always an important factor in analyzing these types of claims. So that would be also under the property coverages as well as the builder's risk and CGL policies as well. Make sure you have a policy, not an insurance policy, but a policy in place for return to work. What measures you're going to be taking to ensure safety, ensure that the site is clean, and what happens, the protocols that would be enforced should there be contamination to effectuate the vacating and safing off of the job and then the eventual return to work. More importantly is follow that policy. There's nothing worse than having a policy that you don't follow. That is exhibit number 1 in court. You knew what you need to do, you had a policy, and then you just ignored it. That's worse than not having a policy to begin with. What can you do to maximize coverage? Well, obviously, document all your losses. Even if you think something's not important, they should keep track of all expenses, even if they have they don't think they're going to be filing a claim. Make sure you provide notice as well, like I said earlier. Third-party claims is another question that we've been receiving a lot. So even though there may not be direct coverage, we can expect third-party claims from tenants, contractors, subs, visitors, vendors, employees, among others. They may allege damage to a third party's property in the form of loss of use or claims of bodily injury tied to exposure. CGL policies and the excess policies should address third-party suits, at least on the defense side, at a minimum. The insured obviously should request that carrier counsel be appointed, as well as indemnity to satisfy the judgment. There are CGL policies with exclusions that try to eliminate coverage for injury due to virus or disease. Indeed, one of the questions that we received overnight asked that question, that the communicable disease exclusion is being implemented on renewals at this point. Other policies that may have COVID-19 coverage, workers' comp. I think Brad sent around an email yesterday with regards to NICEP's position as far as workers' comp claims are concerned. We did receive a question on that, and I'll address that in a minute on that as well. EPLI policies for wrongful termination, discrimination, other types of conduct. So we had a lot of furloughs, a lot of layoffs during this time period. The WARN Act is another area of liability because this was an emergency situation. A lot of our customers and clients may have laid off masses of people without providing the WARN notices. There are defenses to that, but that's not going to prevent claims from coming around. Pollution liability policies is another one that we can look at. And finally, D&O policies may provide some potential for coverage. I know Brad has I saw an email coming up for other types of discussions about insurance coverage, so I'm not going to get into too much detail about that. So turning to the one question that we got overnight. We are starting to see insurers, including our contractor markets, advising they will be adding communicable disease exclusion, CG 2132, to all policies soon. I've heard that. Are they admitting that there may be coverage now? I don't know. I can't speak for a carrier. The fact that they're including an exclusion to the policy means that there may be a fear of coverage, and I think there may be coverage under a lot of these policies, but I wouldn't go so far as calling that an admission. If employee claims that they contracted COVID at work, any idea how a workers' comp carrier will determine if it's true? One of the factors we're going to be looking at, I would imagine, is, and I haven't gotten any feedback from actual workers' comp hearings on these types of claims, but one of the things that we may be seeing is what type of worker is this? In other words, is it a healthcare worker? Is it a first responder type of claim? Is it someone who has a heightened exposure to COVID-19 as opposed to other workers, or being able to contract the disease, just a matter of being in the general public? That's one of the factors that are going to be looked at. The second is, was there a policy in effect with regards to keeping the workplace safe? And second of all, was that policy followed? So again, we're looking at enhanced risk exposure for the particular claimant. So obviously, if you're in a type of position where it puts you into closer contact as opposed to the general public, to being contracting disease, that's one of the enhanced exposures. The other one would be, again, not having a policy or not following the policy with regards to keeping the work area clean. That also puts you at an enhanced risk. Is there any way of clearly determining that a particular individual has contracted the disease at the specific workplace? Not that I'm aware of. It's all going to be a circumstantial, factual analysis that's going to be applied. The problem comes is assuming there's workers' comp coverage, and someone does get ill and the project is shut down. You may see a third-party claim come down from the owner or the GC if it happens to be a subcontractor's employee, alleging damages due to the project being shut down and forces having to demobilize. That's an area where CGL may respond, but certainly your insureds are going to have exposure under their contracts as well, their construction contracts as well. I don't see anyone else with any questions. That was the extent of the presentation that I had to give, in terms of having stuff prepared in advance. Does anybody have? I'm not seeing anything in the chat, so I don't know if anybody has any other questions that they want answered. No?
The chat option is down at the bottom of your screen if anyone's not familiar with it. There's one. There's one.
Yeah. Are the documents contracts you have clients sign before they enter a job site? Very good question. So I've seen a lot of these forms floating around. At the very, very least, there should be a sign in and sign out sheet. There should also be a handout, as well as posters posted at the job site with regards to safety policies. Look first to the owner of the project site to see what safety policies they have put in place. You certainly don't want to be issuing conflicting policies. You can supplement those policies, certainly, if you feel they don't go far enough. But if the owner has a policy, that's your first step. And then down the line, if you're a sub, look to the contractor's policy. Between those two, if they exist, you should have enough. If nothing exists, rely on outside documents such as OSHA, CDC, State Health Department. Don't play doctor and think you know what the symptoms are and what should be done to keep safe. Be very, very careful, as those documents are updated on a constant basis. So make sure you have the most current version of those documents. If you go to any one of those, the State Health Department, CDC, or OSHA's website, COVID stuff is going to be front and center in their websites, and they're all downloadable forms. Have your employees sign a statement, and also require your subcontractors' employees to sign statements that are submitted to you, indicating that they are aware of the guidelines, aware of the steps that need to be taken as far as the policy is concerned to keep safe, and understand that they have a moral and contractual obligation to maintain those protocols and follow those protocols. Do not ask for waivers of liability from your employees. Number one, especially for union situations, that may be a violation of the collective bargaining agreement. Number two is they're not going to be enforceable. The obligation to provide a safe work site is on the employer. It is not on the employee. If you find that an employee is not following safety protocols, they consistently take off their mask, they refuse to wear gloves, you have an obligation to ask them to leave the work site. That obligation extends to the other employees. That employee is putting other employees at risk in that situation, and other visitors to the site as well. That's where the obligation comes from. That's where you're going to have potential liability as well coming from the website. So definitely have an attorney review whatever you're asking employees to sign. It doesn't have to be an affidavit. It doesn't have to be an affirmation. At the minimum, again, a sign-in sheet and an acknowledgement that they have received and understand the safety protocols for the site. Any other questions? Does anybody prefer having this on audio instead of typing? But oh, wait, now they're all coming through. Hang on. Just probably that which was oh, how involved should insurance agency to be in making sure HR practices are adequate? Trying to think how to answer this question. So from an EPLI standpoint, most carriers do have a hotline or department that will assist the insured with regards to HR policies. So I would, as an agent, I would refer them to the carrier directly, and if that service exists. From the HR standpoint of safety, however, number one is I would refer them to their safety consultants, first and foremost. At a second level, if they're not sophisticated enough or don't have that available, then what I would do is refer them again to OSHA or CDC and have them adopt those policies as their policies. Certainly you're not going to be faulted for pointing to the advice that the government is issuing with regards to this. Where you get in trouble is where you try to kind of make up stuff on your own. That could be a potential issue. Can you get a copy of my written recommendations? Yes, I'll email them to PIA, and then they can distribute those. Would OSHA approve you sitting under a crane? I guess it depends on what you're doing. I'm not understanding that question. Any obligation to disclose if someone previously had COVID-19? It depends on what time period we're talking about. If it's within the quarantine period and they show up to the site, then yes, but be careful in terms of disclosure. You only need to disclose to other employees the absolutely relevant information. Relevant information does not include the person's name. If you're the GC and it's a subs employee that contracted COVID, then you have number one, you have an obligation to shut down the site. Make sure that employee is sent home. Make sure he doesn't return until he has clearance from a doctor. So there was a lot of questions about HIPAA violations in terms of requiring that. Under the circumstances, it is not a HIPAA violation to make sure that they have doctor's clearance before return to the work site if they have tested positive. You can also ask that particular employee in a private setting whether they tested positive or not. As far as everyone else is concerned, you would also ask that employee when they were on the site. You should have a record of that if you're keeping a sign-out sheet as well. And ask that employee who they came in contact with, where they were on the site at given times, where they were working during the period that they think they may have been infected. Then you have an obligation to inform those people that a individual has visited the site, they have tested positive for COVID-19. These are the people that they have indicated that they have come into contact with. And it's all done anonymously. We recommend that you get tested. If you know of people that have come into direct contact, then definitely have those people get tested as well. Well, actually recommended they get tested, but definitely monitor them for known symptoms, fever, stuff like that. Having a temperature check to enter and exit the site is a good measure. I know sometimes that's not practicable; it's not required. But again, if you want to include that as part of your policy, it's certainly something that you can allow. Can you send somebody home involuntarily who has or is exhibiting symptoms of COVID? Yes, you can send them home, but be aware if they actually have been tested positive and they are otherwise willing and able to work, then you probably still have the obligation to pay them. If they do test positive, then be mindful of the paid family leave and all the enhanced federal and state programs that are associated with that. Oh, am I sitting under a crane? No, this is the graphic that was provided by PIA. So yes, I guess it does look like I'm in an unsafe situation. Thanks, Ken. That's a good point. Thank you, Kevin and Rich, for the comments. Very kind. Remember to what a lot of your contractor clients are going to overlook is that they also have offices, and that they will be obligated, just like at the construction site, to provide a safe workplace for their office employees, which will include safe distancing as well. Another thing to remind them of is to look first to their landlord. Now would be a good time, as we are coming back to the reopening of offices time period and the lifting of the ban, to start writing letters to landlords. What is the building doing in terms of controlling access? Think about a multi-tenant office building, and what happens when everybody tries to get on the elevator in that closed space. So you may have done everything necessary to protect your particular space in that building, and taking the proper measures, hand sanitizer, masks, gloves, et cetera, and now that everybody comes back to the building, they're afraid to get on the elevator. So look to the landlord first right now. The other reason to kind of do that right now is you may have a lack of access claim, either under your lease or under an insurance policy. And one way to establish that and to show that you've been proactive with it is that you did contact the landlord and put them on notice that they need to take steps to ensure that you are able to get to your space in the building. So safety procedures on the construction site when safe social distancing is not possible. So for example, if COVID-19 and social distancing specifically, safety procedures, are not an excuse for ignoring other safety concerns on the job site. A very good example is again the two-man lift. If a job requires two people to be there, one may be a spotter, or it's an object that requires two people to lift it. Social distancing does not preempt all the other OSHA considerations and safety considerations that already existed. In that situation, if social distancing cannot be maintained because of the nature of the work being performed, then what you need to do is make sure that those people have face masks, make sure that they have gloves, and are only suspending practicing social distancing for the duration of that particular task that is necessary. So if it's intermittent, then I suppose again it's a factual analysis, so it might extend to a longer period. But if it's just something that happens, for 5 minutes of the day, that doesn't mean that the rest of the day they don't have to practice social distancing. So again, it's a very, very a limited time period that these things happen. Let's see. Are claims being handled due to a worker getting covered? Are you referring to insurance? Is that insurance claims or because I have no idea what carriers are doing yet. It's too early. I haven't gotten any results or comments from what carriers are doing. But in terms of internally how the employer is handling those claims, whether they're third party or direct employee claims, is again we're advising our clients to put the carrier on notice and make sure you're hitting upon all policies that potentially could have coverage as far as that's concerned. If they are exhibiting symptoms, that they are sent home and that they receive medical clearance before returning to a work site or the workplace. You certainly don't want one employee who is potentially sick then creating multiple claims from the other employees because you didn't react to that situation. Again, be very, very mindful of employment law claims that may arise in those situations. Talk through what's happening either with the carrier's resources. They have hotlines for this, or if not, definitely consult an employment attorney as to the particular facts of that situation. You certainly don't want to have a COVID claim kind of spawn a discrimination or a disparate impact type of claim or something of that nature. Out of the frying pan into the fire type of situation. Okay, anybody else? Questions?
Any other questions? All right. Thanks, Tom.
Thank you. Thank you. If anybody thinks of something after the fact, feel free to give them my information. They can contact me by email, and I'll be happy to respond in any way I can.
Great.
Thank you for the opportunity.
Yeah, thanks so much. I really appreciate it. And just a reminder that this session was recorded and we'll post it to our COVID information page.
Great.
Thanks, everyone.
Thank you, everyone. Have a good day and be safe.